Did you know that in 2026, thousands of people living in California could suddenly face deportation? Even some who thought they were completely safe? New enforcement rules and legal changes are quietly reshaping how immigration cases are reviewed, and experts warn that the number of people affected may be far higher than what's being reported publicly. What's shocking is that these changes don't only target undocumented immigrants. They could impact workers, students, families, and long-term residents in ways most people never expected. Here's the scary part. Many individuals won't realize they're at risk until it's too late. A small paperwork mistake, an old record, or a missed deadline could now trigger serious consequences. Immigration lawyers are already seeing faster case reviews, stricter checks, and less room for error. And the rules aren't always clear, which is exactly why so many people are caught off guard. So the big question is, who is really affected, and how do you protect yourself in 2026? In this video, I'll break down 10 critical deportation-related laws in California, explained in simple language, so you know what's happening and what you need to do before it's too late. Watch till the end, because the last law may surprise you the most. Number 1. Expanded criminal grounds for deportation. One of the most concerning changes in 2026 involves the broader interpretation of what counts as a deportable offense. In the past, certain minor crimes, especially older misdemeanors, did not automatically trigger removal proceedings. But under updated enforcement priorities, immigration authorities are now reviewing criminal records more closely, even if the incident happened many years ago. What once seemed like a small mistake may now carry much bigger consequences during visa renewals, green card applications, or court hearings. What makes this change more serious is that the review process is becoming stricter. Even cases that were reduced, dismissed, or settled through plea deals can raise questions during immigration background checks. Many individuals assume that because they completed probation or paid fines long ago, the issue is permanently behind them. However, immigration law works differently from criminal law. Certain convictions, even minor ones, can still be considered grounds for deportation depending on how they are classified under federal immigration standards. So what should you do? First, never assume your past record doesn't matter. If you have any prior arrest, charge, or conviction, speak to a qualified immigration attorney before filing paperwork or traveling internationally. Request certified copies of your court records so you fully understand what appears in your history. Being proactive can make the difference between protecting your status and facing unexpected legal trouble. If this information made you stop and think, drop a comment below and tell us which law surprised you the most. Your experience could help someone else. We spend hours researching and simplifying these updates so you don't have to struggle alone. Support our work by subscribing to the channel. It's just one click, but it helps us keep you informed and protected. Number 2. Mandatory data sharing between agencies. Another major change in 2026 is the expansion of data sharing between state and federal agencies, and this is something many people completely underestimate. Information that was once stored separately, such as employment records, court data, benefit applications, and immigration files, can now be cross-checked more efficiently. This doesn't mean everyone will be targeted, but it does mean that inconsistencies are far easier to detect than before. Even small mismatches that went unnoticed in the past can now raise serious red flags. What makes this especially risky is that many people don't even realize where inconsistencies exist. For example, a name spelled slightly differently on a work form, an old address still listed in one system, or income figures that don't fully align across records can trigger further review. Once a file is flagged, it may be shared across multiple departments, increasing scrutiny and delaying applications, or worse, opening the door to enforcement action. This process often happens quietly, without warning, until an official notice arrives. The most important step you can take right now is prevention. Review all your official documents carefully: immigration paperwork, tax filings, employment records, and benefit applications, and make sure the information matches exactly. If something looks wrong, fix it before submitting new forms. Staying consistent and organized isn't just smart anymore. In 2026, it's essential for protecting your immigration status and avoiding unnecessary trouble. If this update raised questions in your mind, write "checked" in the comments and let us know you're reviewing your records today. We put serious time and effort into breaking these laws down so you can stay safe and informed. Subscribe to the channel. It's just one click, and it helps us keep bringing you updates that truly matter. Number 3. Changes to sanctuary policy enforcement. Many people believe that California's sanctuary policies offer complete protection from deportation, but in 2026, that assumption can be dangerous. While California still limits cooperation with federal immigration authorities, new enforcement guidelines have clarified exceptions that many residents are unaware of. These changes don't eliminate sanctuary policies, but they do narrow how and when protections apply, especially in cases involving specific criminal allegations or court orders. The biggest issue is misunderstanding. Sanctuary laws mainly restrict local law enforcement from proactively assisting immigration authorities in certain situations. They do not stop federal agencies from acting on their own authority. In 2026, updated procedures allow limited information sharing or custody notifications in narrowly defined cases, which means some individuals may suddenly find themselves exposed after an arrest or court interaction. This is why relying on California is a sanctuary state, as a blanket shield can create a false sense of security. The smart move is awareness. Know exactly what sanctuary policies do and what they do not do. If you or a family member has contact with the criminal justice system, even for a minor issue, don't assume local protections will automatically apply. Seek legal advice early, understand your rights, and avoid unnecessary interactions that could escalate. In today's environment, clarity and preparation are your strongest defenses against unexpected immigration consequences. If this changed the way you think about sanctuary laws, comment "aware" below so others know they're not alone in learning this. We spend hours researching and simplifying these updates to protect our community. Please subscribe to the channel. It's just one click, and it helps us keep delivering critical information like this. Number 4. Faster removal proceedings and shorter response times. One of the quiet but most dangerous changes in 2026 is the move toward faster removal proceedings. Immigration authorities are now prioritizing speed, which means many cases are being processed on tighter timelines than ever before. For people already juggling work, family, and legal stress, this can be overwhelming. Notices that once allowed weeks or months to respond may now require action in a much shorter window, leaving little room for mistakes. The real danger here is missed communication. Many deportation orders don't happen because someone broke a major rule. They happen because a person missed a deadline, failed to appear at a hearing, or never received a notice in time. If your address is outdated, your mail isn't checked regularly, or you don't understand the document you received, the system doesn't wait. In 2026, courts are moving forward even if someone is unprepared, and that can lead to automatic removal orders without the person fully understanding what happened. The most important protection is staying alert and organized. Always keep your address updated with immigration authorities. Open every official letter immediately, and never ignore paperwork because it looks confusing or scary. If you receive a notice you don't understand, act fast and seek legal guidance right away. In a system that's moving faster than ever, time itself has become a risk, and quick action can be the difference between staying in the country or being forced to leave. If this made you realize how important timing is, comment "on time" below and let others know they're not alone. We put real effort into breaking these updates down so you can act before it's too late. Subscribe to the channel. It's just one click, and it helps us keep protecting you with timely information. Number 5. Worksite compliance crackdowns and employer audits. In 2026, worksite enforcement has become far more aggressive, and this change is already affecting thousands of workers across California. Employers are now facing stricter audits, surprise inspections, and heavier penalties for documentation errors. As a result, many companies are tightening their internal checks, and workers whose paperwork is outdated, incomplete, or misunderstood are suddenly at risk, even if they've been employed for years without any issues. What makes this especially stressful is that many workers don't control how their employers handle compliance. A missing form, an incorrectly filled document, or a delay in renewal can trigger investigations that place employees under scrutiny. In some cases, workers are asked to re-verify their status on very short notice. Those who fail to respond quickly, or who don't fully understand what's being requested, may lose their jobs and attract further attention from immigration authorities. The smartest move is to stay ahead of the process. Always know when your work authorization expires. Keep copies of every employment-related document, and never ignore requests from your employer regarding verification. If something doesn't feel right, ask questions or seek legal guidance before responding. In today's environment, employment is no longer just a source of income. It has become a critical part of protecting your immigration status. If this made you think about your job paperwork, comment "Work safe" below and let others know they should check theirs too. We put serious effort into researching and explaining these laws so you can stay protected. Subscribe to the channel. It's just one click, and it helps us keep bringing you updates that matter. Number 6. Public benefits reviews and eligibility scrutiny. In 2026, applications for certain public benefits in California are facing closer review, and this has created fear and confusion among many immigrant families. While using public benefits does not automatically lead to deportation, the way information is reviewed has changed. Authorities are now paying more attention to how benefit applications align with immigration records, income reports, and residency details. Even honest mistakes can trigger follow-up questions or delays that didn't happen before. The biggest risk here is inaccurate or incomplete information. Many people rely on assistance programs during difficult times, but they may not fully understand how each form connects to their immigration profile. A wrong income figure, an outdated address, or inconsistent household information can raise concerns during background checks. In 2026, these inconsistencies are more likely to be flagged and reviewed across multiple systems, creating unnecessary stress for families who were simply trying to get help. The key is caution, not fear. Before applying for any public benefit, read every question carefully and provide truthful, up-to-date information. Keep copies of all submitted forms and approval notices for your records. If you're unsure how a benefit application might affect your immigration status, seek professional advice before applying. Public assistance is meant to support families, but in today's environment, being informed and precise is essential to avoid unintended immigration consequences. If this opened your eyes about benefits and paperwork, comment "Stay accurate" below so others remember to double-check their forms. We put real time and effort into simplifying these complex updates for you. Subscribe to the channel. It's just one click, and it helps us keep sharing information that protects families. Number 7. Stricter student visa monitoring and enrollment rules. In 2026, students studying in California are facing stricter monitoring of visa compliance, and this change is catching many off guard. Immigration authorities are now paying closer attention to enrollment status, academic progress, and even course load consistency. Falling below required credit hours, taking unauthorized breaks, or switching programs without proper approval can now raise red flags much faster than before, even if the student had no bad intentions. What makes this situation stressful is that many students rely heavily on advice from friends or outdated online information. A simple misunderstanding, like dropping a class to manage stress or finances, can suddenly put a student out of status. In 2026, reporting systems between schools and immigration databases are more active, meaning changes in enrollment can be flagged almost immediately. Students may not receive much warning before consequences begin. The best protection is communication and documentation. Always stay in close contact with your school's International Student Office before making any academic changes. Confirm whether part-time enrollment, online classes, or program transfers are allowed under your visa. Keep written approvals and emails as proof. Education is meant to build your future, not risk it. And in today's environment, one uninformed decision can create serious immigration problems if you're not careful. If you or someone you know is studying in California, comment "Student Alert" below so this message reaches the right people. We put real effort into breaking down these rules to protect futures and careers. Subscribe to the channel. It's just one click, and it helps us keep students informed and safe. Number 8. Tighter asylum application deadlines and documentation rules. In 2026, one of the most serious changes affects individuals applying for asylum in California. Authorities are now enforcing filing deadlines and documentation requirements more strictly than before. Missing the one-year filing deadline, or failing to properly explain delays can result in automatic denial of protection. What used to allow some flexibility is now being reviewed with far less tolerance for incomplete files or late submissions. The challenge many asylum seekers face is complexity. Asylum cases require detailed personal statements, supporting evidence, and proof of fear of persecution. Gathering documents from another country is already difficult, but in 2026, incomplete submissions are more likely to be rejected instead of given extra time for correction. Even minor paperwork errors, missing translations, or inconsistent timelines in written statements can raise credibility concerns that weaken an entire case. The most important step is preparation and urgency. If you plan to apply for asylum, begin collecting documents immediately and keep clear records of dates and events. Never wait until the last minute to submit forms. If you already filed, keep copies of everything and track every notice carefully. Asylum law can be life-changing, but in today's climate, strict deadlines and accuracy are critical. Acting early and staying organized could mean the difference between protection and removal. If this information felt important, comment "Don't wait" below so others understand how serious these deadlines are. We put real time and effort into explaining these rules so no one is caught unprepared. Subscribe to the channel. It's just one click, and it helps us keep sharing life-changing information. Number 9. Expanded detention authority during immigration proceedings. In 2026, one of the most alarming developments is the expansion of detention authority while immigration cases are still pending. This means that in certain situations, individuals may now be held in detention before their case is fully decided. Many people assume detention only happens after a final deportation order, but under updated enforcement priorities, that is no longer always true. This change has increased fear, especially for families who never expected detention to be part of their situation. What makes this even more stressful is how quickly it can happen. A routine check-in, court appearance, or enforcement action can suddenly lead to detention without much warning. Once detained, access to legal help becomes harder, communication with family is limited, and case preparation becomes far more difficult. For many individuals, detention itself becomes a powerful pressure tool, pushing them toward rushed decisions without fully understanding their rights or options. The most important protection is preparation before anything happens. Always carry emergency contact information, know your legal rights, and have a plan in place if detention occurs. If possible, secure legal representation early, not after a crisis begins. Detention does not automatically mean deportation, but navigating a case from inside a facility is much harder. In 2026, understanding this risk and preparing for it can make a critical difference in how your case unfolds. If this made you realize the importance of being prepared, comment "Know your rights" below so others see this too. We put deep research and real effort into explaining these risks clearly. Subscribe to the channel. It's just one click, and it helps us continue sharing information that protects families. Number 10. Enhanced Green Card Renewal Rescreening. One of the most surprising changes in 2026 involves green card renewals. Many permanent residents assume that renewing a green card is a routine process, just paperwork and waiting. But under updated review procedures, background checks during renewal are becoming more detailed. Authorities are now taking a closer look at travel history, past applications, prior addresses, employment records, and even older legal issues that may not have caused problems before. What makes this shift important is that renewal is no longer treated as automatic. If inconsistencies appear between past filings and current information, it can trigger requests for additional evidence or extended review. Even something as small as outdated information from a previous application can raise questions. Some applicants are experiencing longer processing times because their cases are undergoing deeper verification. For those who have had past immigration complications, the risk feels even greater. The best strategy is preparation. Before submitting a renewal application, review your full immigration history carefully. Make sure your travel dates, employment details, and personal information are accurate and consistent across all documents. If you've had prior arrests, status issues, or extended trips abroad, consult a professional before filing. A green card renewal may seem simple, but in 2026, thorough preparation can prevent unnecessary delays or serious complications that could impact your long-term residency. If this surprised you, comment "prepared" below so others know renewals aren't automatic anymore. We put serious time and effort into researching and explaining these changes to keep you safe. Subscribe to the channel. It's just one click, and it helps us continue delivering critical updates like this. As you've seen, the 2026 deportation-related changes in California are not just small policy tweaks. They represent a shift towards stricter reviews, faster timelines, and deeper background checks. While not every update automatically leads to removal, the margin for error has clearly become smaller. A missed deadline, an outdated address, an old record, or inconsistent paperwork can now trigger consequences that many people never expected. The most important message from today's breakdown of these 10 major laws and enforcement changes is simple: preparation is power. Whether you are a student, worker, asylum applicant, green card holder, or someone with a pending case, staying informed can protect your future. Many families panic only after receiving a notice, but by then, time is already limited. Acting early, reviewing your documents, keeping records organized, and seeking guidance when necessary can dramatically reduce risk. It's also important to remember that immigration law is complex and highly individual. Two people with similar situations may face completely different outcomes depending on details in their history. That's why relying on assumptions, rumors, or outdated information can be dangerous in 2026. Laws evolve, enforcement priorities shift, and procedures change quietly. Staying updated is no longer optional. It's essential. If this video helped you understand what's happening, don't keep it to yourself. Share it with someone who may need this information. Knowledge can truly protect families during uncertain times. And finally, remember, this content is for informational purposes only and does not replace professional legal advice. Always consult a qualified immigration attorney for guidance specific to your case. Stay informed, stay prepared, and most importantly, stay proactive.